Hello, everybody, and welcome to NZYQ. What's next? I would like to acknowledge that we are on unceded Gadigal land and pay my respects to elders past and present of the Gadigal people, and extend that respect to any First Nations people here in the room this afternoon or online. Thank you so much for joining us here this evening. I'm hoping that we will be in for a very fascinating discussion with our three very eminent speakers. We're very honoured to be joined by Professor George Williams of the University of New South Wales Law and Justice faculty. He is a leading constitutional scholar who has written on NZYQ and similar cases. I'm sure many of you will be familiar with his work. Here to my right, I have Paul Cody, who is a New South Wales public defender. For those of you who don't know, public defenders are statutorily appointed, publicly funded criminal defence barristers who represent people accused of serious crimes. They take briefs from legal aid and community legal centres as well. And so Paul is in a really good position this evening to advise us about how some of the developments that we've been seeing in the immigration space lately have been playing out in the criminal law space up until now. And also online, we have Sanmati Verma, who is the Acting Legal Director at Human Rights Law Centre. Hello, Sanmati. Sanmati represents a number of clients in immigration detention currently, so she's really on the cutting edge of what we're going to be talking about tonight. She, along with the Caldor Centre, intervened as amicus curiae in NZYQ. Sanmati continues to be involved with many of the cases that we will see going forward, and has been involved in many of the cases that we have seen to date. So please join me in welcoming our panel. Thank you. So firstly, I'll introduce the Strategic Litigation Network, for those of you who are not familiar with it. I'll then give you a quick rundown of how the evening will run, and a quick explanation for those of you who don't know about NZYQ, which is a big case in the immigration space. We will be speaking in a conversation style for about 55 minutes, and then there'll be about 15 minutes for audience Q&A. So if you have your questions, please get your hands up quickly, because unfortunately there won't be as much time as we would like for Q&A. We're also able to take questions online, so please just put your questions in the relevant part of the chat for that, and if we have time, we'll get to that as well. I won't prioritise in the room or online, so we're very keen to hear from all of you. So this evening's panel discussion is designed to draw insights and connections from different areas of law. Many of you will be familiar with immigration law, and it connects quite regularly with constitutional law. So we have the immigration lawyer and the constitutional lawyer here to provide us insights about how those connections operate in practice, particularly recently. What we're less familiar with, I guess, is that this also interacts and has analogies with criminal law. So what we've seen unfold in the last 6 months or so is much more relevance between the two areas of law, immigration law and criminal law. So having Paul here to provide those insights is a real privilege. In case you've been hiding under a rock, NZYQ was what we thought the most exciting immigration case of a couple of decades. At the time, I, for one, wanted to start dancing in the streets. It was very exciting. It overturned a case called Al-Kateb, which had effectively allowed for indefinite immigration detention. So with NZYQ, we found that, in fact, indefinite immigration detention was not permitted, and if there was no reasonable prospect of someone being deported within a reasonably practicable period of time, I'm not sure if I got that correct, but I'm sure Sanmati will correct me if I didn't, then the High Court found that they were not validly detained. And so we saw about 150 people being released fairly quickly after NZYQ was decided. Again, these are, great things that we're seeing. But then within a very short amount of time, some fairly serious legislation was being passed, some fairly serious visa conditions were being issued on the people who were released following this case. Since then, we've seen a series of laws tightening the freedom that people who were released are living under. And even last week, we saw a law rejected because it was considered, well, I won't speak for the senators who rejected it, but it was sent to a committee, and we will be hearing about that again in May, I believe. So without further ado, I will get on to the questions. So the first one is for you, San Marti. What do you consider to be some of the current challenges that people have been facing following NZYQ around their visa conditions in particular? And have these conditions been challenged in court?
Thanks, Anna. Thanks, everyone. Can you hear me okay, everybody? That's so great. I'm so sorry. I have the world's worst tech. So let me try and answer your question in a very roundabout way without boring anybody. The story obviously starts at 4:33 p.m. on the 8th of November when the High Court made orders in NZYQ. Those orders obviously granted NZYQ his liberty, but it didn't change his underlying legal status under the Migration Act. He was, at the time of those orders, and remained an unlawful non-citizen within the meaning of the Act. All that the orders did was mean that from 4:33 p.m. on the 8th of November until such a time that there was a real prospect of NZYQ's removal becoming practicable in the reasonably foreseeable future, he couldn't be detained. So in order to regularise NZYQ's status, which is the way that migration lawyers talk about these things, he was granted without application a bridging R subclass 070 visa. That visa was not created for him. It was in fact introduced to the migration regulations in 2005 in direct response to Alcatab and Godwin. It was specifically designed for people who had been detained long term and in relation to whom there was no serious prospect of removal from Australia in the foreseeable future. In fact, it was designed precisely for people who had previously been convicted of crimes, and the visa, I think it was, as it was initially designed, was subject to some 8 conditions that restrained sort of place of residence and imposed other reporting requirements, but otherwise were not subject to the type of serious restrictions that we now see. So as a result, in the immediate aftermath of NZYQ, another around 149 people in total were released from detention. The bridging R visa regime has been twice amended from that time until now. And basically what we have now is a regime for the grant of these visas without application to people, subject to 8 further mandatory conditions and 4 discretionary conditions, as well as 9 new criminal offences relating to breach of a number of those conditions, attracting a minimum mandatory term of imprisonment of 12 months, with each separate breach constituting a separate offence. So the mandatory conditions, I won't bore you, I've got a table if anyone's keen to see it, are restrictive enough. They require visa holders to, for example, seek permission to travel interstate, to obtain ministerial approval before engaging in any activity that would involve more than incidental contact with a vulnerable person, these terms undefined, and refrain from going within 200 metres of a school or childcare centre if the visa holder has previously been convicted of a crime involving a vulnerable person, again undefined. So those are restrictive enough. They're the mandatory conditions, but the discretionary conditions are where things get particularly draconian. So as amended, the migration regulations provide that these conditions are discretionary in the sense that they must be imposed unless the minister is satisfied that they are not reasonably necessary for the protection of any part of the community. And they include the very controversial conditions. So 8620 and 8621, respectively, a curfew and a requirement to wear an electronic monitoring device. and then 2 other discretionary conditions that relate to the receipt or transfer of more than $10,000 by the visa holder. So all initial bridging R visa grants were made subject to these, of course, the mandatory conditions, the previous conditions to which bridging R visas were subject in their initial iteration, and these 4 discretionary conditions. And then it was on the visa holder to apply or make representations to seek variation of those discretionary conditions. That was the visa holder's responsibility. The government convened something in December called the Community Protection Board, the composition of which remains to us slightly mysterious, but there are representatives of the Australian Border Force on it. And the purpose of that board is to make recommendations to ministerial delegates regarding individual requests to vary bridging R visa conditions. So what we understand is that the Community Protection Board and the department and ministerial delegates are working their way one by one through these requests to vary visa conditions, the result of which currently is that 73 people currently hold bridging visas without the electronic monitoring condition, and 79 are still subject to those conditions. The entire process was stalled by the fact that just earlier this month, the department, in the course of litigation, but affecting the entire cohort, realised that there was a defect in the way that the initial bridging R visas have been granted, the result of which is that all visas had to be re-granted, restarting the clock on making representations to seek variation of the conditions. So, as well as all of this, in the meantime, an Eritrean man who is in a very, very difficult position and goes by the pseudonym YBFZ has commenced a High Court challenge to his bridging R visa, arguing that the curfew and electronic monitoring conditions constitute a form of periodic detention and a serious interference with his bodily integrity, privacy, and dignity, that they therefore constitute a form of punishment by the executive in the LIM sense and are not animated by a legitimate object of the kind recognised in LIM. So that case is working its way sort of agonisingly through the High Court and is likely to be heard in June or July this year. That would, of course, call into question the entire regime, or at least insofar as it imposes these very restrictive conditions on people. But to give you a sort of practical example of how this is affecting people on a day-to-day basis. So, for instance, we're dealing with a very elderly man who's been released from detention, who was long ago convicted of a single people smuggling offence relating to a member of his own family. Because that offence has been deemed by the department to constitute an offence in relation to a vulnerable person, he is no longer able to take his grandchild to school or collect his grandchild from school. So this is the way that the conditions are operating. Another man that we assisted recently was subject to a curfew condition. And of course, people have been detained for a very long time, so they have untreated medical conditions, was experiencing chest pains, thought he was suffering from reflux. It was 11 o'clock at night. He decided to put himself to bed, woke up the next morning, same experience. Late that night, decided to breach his curfew, went to hospital, realised that he had a blood clot, and that if he'd let it travel any further, he could have had a fatal stroke. So these are the types of things. I'll give you another example. This morning, I received a medical report from someone's doctor at Cabrini Health saying that because he's a diabetic, the electronic monitor is restricting his circulation to his foot. He's at risk of amputation. So these are the type of restrictions to which people are subject without any serious regard. And as I said, the mandatory conditions are in themselves very restrictive. They're not the subject of challenge in the High Court proceeding. That concerns only these more punitive curfew and electronic monitoring conditions. So we have here an apparatus that is highly restrictive, that is not modelled on really any restrictions to which visa holders have previously been subject in history, and is bespoke for what we must admit is a tiny, tiny group of people. Some of whom have previously been convicted of an offence, but of course none of whom were serving a criminal sentence. So that's the position that we're in, and it's a tricky and convoluted one.
Tricky and convoluted. I mean, I think that's the least of it, really. It sounds like it's potentially quite dangerous for the people who are subject to these conditions. We have not seen these kinds of conditions in immigration and migration before. That's definitely true. They're the kinds of conditions that we are more familiar with when it comes to criminal law or counter-terrorism efforts, for example. So I've got a question for each of Paul and George about these issues. I'll go to you firstly, Paul.
Sure.
what kind of conditions are being imposed on people that are similar to this in the criminal law context?
So thanks, Anna. There's two regimes. One is the Bail Act, and I'm speaking specifically about New South Wales, but each state and territory will have their own equivalent piece of legislation. And there's also the post-sentence regime, which is for high-risk sex and violence offenders, and also violent extremists and terrorist offenders. That post-sentence regime exists both in state legislation and in federal or Commonwealth legislation. And so that they both have different approaches. The bail approach, they're not dissimilar conditions, but it's much, generally it's left to the discretion of the court. There are heads of conditions that can be provided. So there are conduct requirements. The court can consider bail conditions, stopping a person or making a person do things, accommodation requirements, residing at a particular place, accompaniment requirements, that is, they have to be accompanied in the community with someone, enforcement requirements such as to comply with police directions or to refrain from drugs and alcohol, and they can also require electronic monitoring, although it's not as often ordered in the bail context. The important issue with bail is that breaching a condition of bail is not a criminal offence. What it is a trigger to allow for the reconsideration of bail. So there's no penalty to breaching a condition of bail in New South Wales, but there is a power for the New South Wales Police to rearrest, to bring the person before a bail justice and to have bail reconsidered. There is, however, it is a criminal offence to fail to comply with it, that is to attend court, and that is a criminal offence, and it carries, I think it's 3 years jail as a cap. So that's bail. Within the post-sentence regime, that is similar to what we might be speaking about today, which is community safety orders. These orders are much more similar to the regime that Sanmad here has just described. And so we're very used to those type of very intrusive powers in terms of electronic monitoring, housing, medication, forced therapy, forced work. Things like that are not unusual to us, and courts are not squeamish at all in terms of ordering them.
Okay, so we see a system under criminal law where prior to conviction, where someone is accused of a crime, they're subjected to bail conditions that are very much tailored towards their own situation. There's no automatic bail conditions. And then it's after release that we see those sort of more stringent conditions being available. We'll get to the post-release conditions in a moment, but I just wanted to bring you in, George, about the kinds of conditions that we've seen in relation to terrorism suspects and terrorism offenders. So those of you who are around around the 2000s, 2010s, there was a lot of legislation being adopted in relation to people suspected of terrorism crimes. And there was a regime that was introduced for control orders during that time. That was challenged by the High Court in a case called Thomas and Mowbray. The court found that control orders, which were restrictive, which did monitor, from memory, people's movements and had some similar kinds of restrictions, but that was found not to be a punishment in breach of Chapter 3 of the Constitution. So I was wondering, George, if you could tell us a little bit about control orders and how they operated in line with the Constitution.
I will, and I'll give you a bit of broader context as well, because as much as the current spate of lawmaking is startling, quick and disturbing, we have gone through this before in the counter-terrorism space. In fact, we're up to about our 100th counter-terrorism law over the last 20 years, and at the high point after September 11, for a period of about 5 or 6 years, we averaged a new national counter-terrorism law roughly every 6 weeks in Australia. So 5 years, every 6 weeks. Very reactive, as draconian as you could imagine, and led to a lot of litigation. So this for me is, I'm getting flashbacks, as I have to say, because I've gone through this before, and it raises a lot of similar issues. The High Court has engaged directly with those terrorism laws, and they do raise quite similar issues. You've raised the control order regime, quite similar in some respects to the quite restrictive visa conditions, where you can impose curfews, you can restrict communication devices, you can subject someone to house arrest, who they can communicate with. a range of orders can be made. And in that Thomas and Mowbray case in 2007, the High Court upheld that regime, said it did not breach the separation of powers. And the other case that's particularly important is the case dealing with community detention orders in 2021, where the High Court also dealt with a regime saying you could keep someone convicted of terrorism in jail after their sentence. So in fact, ongoing detention without conviction of a crime. And the High Court also upheld that regime. So there are two key precedents, Benbrika and Thomas and Mowbray, that I think the High Court will be relying upon heavily in this space, because they won both of those cases. And those are significant because they're both dealing with federal regimes. Paul's got very good points about what happens at the state level, but the restrictions are much less at the state level. Chapter 3 does not apply in the same way. You can impose far greater restrictions. You can restrict liberty in ways that would not be possible at the federal level. So these are national schemes being upheld. When I look at those decisions, I've no doubt the Commonwealth will use them, rely upon them, even to the extent with the new detention regime post NZYQ, they've basically modelled the legislation on the terrorism ongoing detention. They've copied the words across as much as possible. They've made it identical in order to shoehorn into that decision. But there are a few factors, I think, across both of those cases that could well lead to a different outcome. Highly unpredictable, but there's a few factors. One is it is terrorism. I mean, that's a different issue. And in fact, in the Benbrika case, there's a quote from the majority that gives you a sense as to how they viewed it. They said terrorism poses a singular threat to civil society. So a singular threat. There's a strong argument there. What we're dealing with is not comparable to terrorism. We're not dealing with the possibility of catastrophic loss of life. We're dealing with to what extent is community protection justified for people who need to be released because they can't be deported, where if they've been convicted, it might have been some years in the past and they have served their sentence. It's very different to someone who is still in detention with regard to a terrorist crime. So I think terrorism itself can make a big difference as to what might occur. The second factor is there are differences in the legislation, and as much as the Commonwealth has tried to base it on the terrorism model, there's key differences. They've had to make it different because if nothing else, these people aren't still in large part being held in prisons. They've served their time, they've been released to the community. That's fundamentally different to saying a continuing detention order applies to someone and they're still in prison and you continue their prison sentence. And I think the court could well look at that differently. There's also the fact that the refugee regime applies to convictions in overseas courts, not just Australian courts. That might be quite significant because we're dealing with people, let's say they've been convicted of a serious crime in a country where they've been subject to a political trial. Is the High Court really going to see that as a legitimate basis for determining dangerousness in order to say it's valid to actually have continuing detention? And you've also got other issues, but for me, the biggest one is simply that these people are not actually necessarily in custody at the moment, but it's hard to assess their dangerousness. And look, the final point I'd make about what may make this different between those earlier cases is the court has changed. I mean, Thomas and Mowbray, 2007, Benbrika, yes, 2021, but the fact Al-Kateb was overturned is a sign of the times have changed. And in particular, Chief Justice Stephen Gageler was actually in dissent in Benbrika. So now he's in the majority. The court's changed its approach. It's a different court. I'd be cautious about relying too heavily on decisions in a different area with a singular threat when the court has changed. But I just end by saying this is a fiendishly complex and difficult area, a lot of value judgments. The High Court's overturned 20 years of law. They're now trying to catch up quickly. The legislation's scrambling to catch up as well. And I have to say it's highly unpredictable as to what will occur because NZYQ gives us the barest beginnings of understanding how they will approach these issues. And all I can say is I'm absolutely sure we'll see a succession of quick cases. We're already seeing those, but this will play out over 5 to 10 years. That's the normal time frame for High Court really working out the details. And at the end of 10 years, I think we'll have a clearer sense as to what the parameters are.
Be back here in 10 years, everybody. And I'm honestly not sure whether I should be reassured or horrified that this is not new. But we are here nevertheless. And I think your point about the fact that overseas convictions can be used in part of this regime is really an important one because another way to see that is sometimes people's refugee claims are actually based on the fact that overseas convictions can be seen as persecution. So
I'll just say on that, I think this is why it's so important which cases go to the High Court. That in many ways, I think, will be determinative of where this goes to. If people pick the wrong cases that aren't compelling in terms of facts, and we've already had some really good examples of compelling issues that raise problems, but if it's not strong, it's less likely you're going to get the strong result in the High Court. And I'd be picking cases very carefully, even if some patience is involved. Commonwealth is already very clearly doing this in terms of certain cases not wanting to go forward. And if people blink too early and bring the wrong cases, the wrong precedent will occur. And that would be very, very problematic. But that's happened in many cases in other areas where, where people are keen, but too early, wrong case, and, you set down the rules for that decade or more.
yeah, exactly. It's a very fraught space right now, and it's very important that we are deliberate in the cases that we invite the High Court to examine, really. So that brings me to the title of the event, I guess, is Community Safety Orders. So we've spoken a bit about visa conditions and how they're analogous to other areas of law, but and community safety orders are the same thing in that they are analogous to other areas of law, but they're unique to immigration law, absolutely. So Sam Marty, do you mind telling us what a community safety order is and how they might be issued against people who have been released following NZYQ?
Yeah, sure. Just after I, recover myself from George's prediction that's dictated the next 5 to 10 years of my life. So the community safety order regime was rushed through in December. As George and Paula both pointed out, it's modelled very closely on the federal high-risk terrorist offenders regime. So the legislation in late December, inserted a new Division 395 into the Commonwealth Criminal Code, largely modelled on Division 105A, which relates to high-risk terrorism offenders. The new provisions allow the Minister for Home Affairs to apply for and the court to impose either a community safety detention order or a community safety supervision order. Together, these are known as community safety orders. So they can be made in relation to a non-citizen who's over 18, in relation to whom there's no real prospect of removal in Australia becoming practicable, so the NZYQ court, in the reasonably foreseeable future, and who has been convicted, as George pointed out, either in Australia or overseas of a serious violent or sexual offence. And an order can be made regardless of whether or not a person is currently serving a term of imprisonment or they're residing in the community. So a detention order, a court can make an order of that nature where satisfied to a high degree of probability that the person poses an unacceptable risk of seriously harming the community by committing a serious violent or sexual offence. And there are no less restrictive measures available to effectively contain that risk, either under the community safety order regime, so by way of a supervision order, say, or under the Bridging R visa regime. So the two regimes are in dialogue. Then when it comes to a supervision order, a court can make an order of that nature if satisfied on the balance of probabilities. So at a lower level, that the person poses an unacceptable risk, seriously harming the community by committing a serious or violent offence, and that bridging our visa conditions wouldn't be effective to manage that risk, and further that each of the conditions to which the supervision order would be subject individually and cumulatively are reasonably necessary and reasonably appropriate and adapt to containing the risk. So as far as we're aware, no community safety order applications have been made to date, though there's been much reporting of the extent to which the Commonwealth is lawyering up, with reports of, 40 new lawyers being hired by AGS and things like this. I suppose, if you ask my perspective, given that the Minister bears the burden in relation to these applications and the high threshold that has to be crossed in order for either type of community safety order to be made, you would assume that the Commonwealth's more immediate focus would be on preparing such applications for people nearing the end of their sentence, so who are currently in custody, coming to the end of their sentence and about to be transferred to immigration detention, rather than those people who were recently released into the community, all of whom would have served their sentences long ago, and in relation to whom the reality is there is simply no current evidence of risk available to the Commonwealth at all. which is the entire reason that we're here and also angry about it. So that's where I think these applications are going to start being prepared. It's clear that some work is being done towards the preparation of applications, but I doubt that it's going to be in relation to the people who have recently been released or who are going to soon be eligible for release, because their sentences would have concluded long, long ago.
Absolutely, and it is, as we've heard, reminiscent of a system that is now well known to criminal law, continuing detention orders. So, Paul, tell us about continuing detention orders. Who are they going to be sought against? How do we know if a continuing or a community safety order is likely to be sought against our client? What kind of evidence are we going to be receiving, and what kind of evidence do we need to provide to respond to these applications?
Thanks, and thanks, Marty, for that introduction to it. The scheme, it is similar to both the state and the Commonwealth regimes. I think from a practical perspective, the first thing you have to be concerned about if you're going to be the recipient as a legal representative to one of these is the time frame. Section 395.9 has a very tight time frame between service of the application, that is, the Immigration Minister serves the application on the respondent, and their first hearing, which is a mandatory hearing, is held 28 days after service. So if your client is unrepresented at the time of receiving it, I usually act on about a month from my client receiving an application to actually working their way through the legal aid, or in your instance, as the community legal service centre, legal sector, to getting that to you. So you might actually get that 2 weeks before the preliminary hearing, if you're lucky, or even worse. The issue for that as practitioners is that a critical decision has to be made at the preliminary hearing, and that is as to whether the court appoints an expert to assess future risk. In both state and the Commonwealth regimes, we have court-appointed experts, psychiatrists or psychologists, who are appointed to look at all of the material that the applicant is relying on and make a determination. And there are two things that flow from that. One is, as a legal representative for the respondent, you have to make a decision as to whether you want an expert or not. In both the state and the federal regimes, we don't get that decision. An expert is appointed. This Act appears to give the court the discretion whether to appoint an expert or not. That seems to me to say that the court can just make the decision without an expert. From a resources point of view, I would have thought, and now I don't work in your space, that if you have limited resources, that getting a court-appointed independent expert to review the material may actually work to your benefit if you're working with limited resources. They have to undertake the very laborious task of going through all of the documents which the government relies upon and making an assessment of risk. You might decide, though, that you will do a better job of that, and so you might resist an expert being appointed. There can be more than one expert appointed. You can serve your own defence or defendant expert report. That won't be a court-appointed expert. There might be the feeling that it won't be as independent. So critical issues need to be addressed at that preliminary hearing, and you need to have had time to take instructions and get over the brief. I think that's a real risk factor for you as practitioners, that pushing down of time. In terms of how you'll know, most of the time it's a letter just saying we're considering your client, if you're on the record, to be subject to a supervision or detention order. If the person is unrepresented, there are actually specific provisions later in Part 9.10 that deal with unrepresented litigants, and there is the potential for delay and also stays if the person's unrepresented. Deal with that if your client is running very close to time. However, I want to raise one particular issue that arises in all of the regimes across Australia, and that is assessment of future risk and what tools these experts can use. Often, psychiatrists and psychologists that are appointed will use what are known as static assessment tools, and they are tools that have been tested on populations of offenders overseas, either in the sexual recidivism space or violent recidivism space. So I'll use some names. One is called Static 99. another is called RSVP2, and there's another called HS. So those two are what are called sexual reoffending tools, and the HCR20 is a violence reoffending tool. They are all scientifically valid and based on very robust figures. When you start moving into the space where your client is alleged to be a violent extremist or a former terrorist in the Commonwealth space, you start moving into very troubling area where there's a significant debate between experts. And that's the critical type of decision that you will need to make at that preliminary stage as to what type of expert, whether they're going to rely upon the extremist or terrorist type assessment tools, which are hugely problematic. And you would need to then, if the government is relying upon those, then you'd need to pick particular experts who will respond. And you will have a very good argument to knock out, as in make inadmissible, any opinion by a court-appointed expert based upon these assessment tools. So that's one of the most important tasks, and I think will place you under some quite tight time pressure. I wanted to raise two other points, but I also wanted to give Professor Williams and San Marti Verma the opportunity to speak about that if you wanted to.
But before you do, I just wanted to flag that one of the issues that I can see arising here is that people who are currently in prison, who have been convicted of a crime, may not actually be engaged with immigration lawyers yet. And criminal lawyers also may not be aware that this is a potential outcome for their clients as they're about to be released. So there's a lot of unknowns here, and perhaps a need for some education beyond the immigration space for people who are representing those who are coming out of prison. But I agree, I'd love to hear from perhaps George first and then San Marti.
And I agree with that assessment. I'd actually be surprised if this regime is used that often. And I think San Marti's right in identifying they are most likely to identify people coming to the end of a really serious offence and then apply it to them. It's too hard, I think, to apply it elsewhere. And actually, it's constitutionally vulnerable, highly vulnerable, I think, if they apply it in other contexts. So we're actually talking about quite a limited cohort of people, those people who fall within this serious crime, coming to the end of their sentence, and the others are just very unlikely, I think, to be picked up by the Commonwealth. When it comes to that narrow cohort, I actually think it's a really hard test for the Commonwealth to get over here, much harder than the terrorism context. We're dealing with someone, again, potential for catastrophic life. You've gone through a full criminal trial. They've been in prison for a long period of time. It's been proved possible to show to a high degree of probability on the basis of admissible evidence that the risk continues. But if you think of those tests, high degree of probability, not easy to get. Admissible evidence, often not easy to get in this area. So they're two key challenges for the Commonwealth. And then, as Paul has indicated, the really contentious one at the moment is the future risk. Courts are really understandably reluctant. I mean, it's one thing to say you did something or you didn't. It's another thing to say what you might do. And there's a lot of contention around those tools at the moment. The Independent National Security Legislation Monitor really came in strongly against the tool used in the Benbrika case and essentially identified that the government had not revealed information about the problematic nature of that tool. And that's where we are. So the Commonwealth is in a difficult spot. It doesn't necessarily have a better tool in this area, because by nature, any tool focused on predicting future conduct is problematic and difficult. And I think the courts now have their eyes open after the Benbrika case about placing too much reliance upon some of these tools as used by the Commonwealth.
Did you have anything to add to that?
No, I don't. How could I possibly? No. I think, look, we are all hoping that what Professor Williams says is correct, and that these applications are going to be rare, and when they are made, that courts vigorously examine the basis of the asserted risk posed by the person, and this is yet another reason why you can't see applications of this nature being made in relation to people who have just been out of detention, because the risk assessment that's being conducted in relation to them is being conducted based on some of the most effective methodologies that you could imagine. So through tools developed by the Australian Border Force and administered through people who have no particular expertise in forensically assessing risk at all. people coming to the end, non-citizens coming to the end of a criminal sentence are in a much, much more difficult position. And in relation to people like that, you're quite right, Anna. I think there's going to be a lot of need for immigration lawyers to get their head around criminal law, and for us to all sit down together and make sure that people are robustly represented at the earlier stage, so that they're not just left to their own devices at the end of their sentence, both being in immigration detention and then being subject to these very fast-moving applications, including that require them to submit themselves to forensic examination and so forth.
And so, Marty, I suppose I'd say if it's not rare, that increases the chances it'll be struck down, because they'll be forced to go to cases which actually are not strong cases and raise issues around overseas courts too long since they served their sentence. So if nothing else, I suspect the Commonwealth will be cautious because they know the whole scheme may be undone.
They'll be picking their cases as well.
Could I respond?
Please, go ahead.
Could I just respond to that? I hope that's the case. What I do remember, though, is when the high-risk offender regime was brought into New South Wales and the Commonwealth regime, both of the second reading speeches talked about how rare it was going to be for these pieces of legislation to rely upon, and there would be a tiny proportion of offenders in custody that they would actually apply to. Now we have dedicated lists in the Supreme Court and dedicated judges and dedicated registrars because the courts are overwhelmed with these cases. I take your point, Professor Williams, in terms of the Commonwealth will be cautious. They were cautious with this in the state and the Commonwealth regime. They are now not so cautious. They're a little bit more cavalier. Can I also say that one of the real difficulties with risk is where you have someone with a cognitive difficulty or a mental health impairment. And that's when the issue of risk looms much more significantly. It might be a tiny cohort, but people with those types of difficulties unfortunately do fall into a category of higher risk just by the nature of their difficulties. And so there may not be published material, forensic reports, they may not have participated in any rehabilitation program, but even the fact of their disordered thinking or disordered behaviour is sufficient, in my experience, to form a basis for future risk. The final matter I wanted to raise was that I take what you say, Professor Williams, in terms of it, having the burden of proof, the standard of proof being significantly high. It is in relation to detention orders. It's significantly lower. It's a civil standard balance of probabilities in relation to supervision order. And that's really where I think that the bulk of these applications will come. And I don't think that's a very high standard. And certainly, again, I say that courts at the first instance, and I take we're talking about different levels here, are not squeamish in being satisfied of risk.
No, I agree completely. And I suppose my stronger comments are reserved completely for that stronger form of detention with the higher standard. And it's like the visa conditions. They have a variety of other lower constitutional risk avenues to impose restraints. And that's where I think the real litigation will be. And I'd simply say on that issue as to rareness that I think there's a difference between the federal and the state regimes. The state regimes are a much stronger constitutional ground. There's a reason that I think they're able to do more at that level. But if the Commonwealth did get this struck down at the federal level, it actually has the option of trying to reenact it through the states. And that's the federal option. Undesirable perhaps, but they've acted quickly. But they have a number of other options up their sleeve, even if they lost a High Court case.
And that's my question as well. Why would they use this regime when there's the state-based regime available, presumably for the same people?
Well, the state regime doesn't really apply a lot of the time at the moment. The state regime isn't broad enough to cover this category. But what they might have done, I thought they might have done, is actually negotiated through the states to extend those regimes, but they didn't. I think the political pressures are so high, they wanted immediate legislation, not to work through the National Cabinet and other bodies, but that remains open to them.
Absolutely. So, Marty, did you have something to add?
Yeah, I did. I was going to say somebody's got to be right here. So Professor Williams is right. A slew of applications will flow and they'll be constitutionally unsound. Or if Paul is right, we're all going to be in serious trouble, and these applications are going to be made all the time, particularly for community safety supervision orders, and we're going to be in real trouble. I suppose in that scenario, a couple of things occur to me. The first is that we need to pay real attention to which, I think we may not have done in in a sufficient way to date, which is just how different the experience of incarceration is for people based on their visa status. So NZYQ, for example, attempted to access various rehabilitation programs in prison and was precluded from participation because he was on a so-called cancellation pathway. This is a common experience for our clients. So precisely the type of evidence, well, you can't take steps that would actually mitigate the so-called offending risk that you pose, or even be seen to mitigate that risk. So already, because of your visa status, you're going to be on the back foot when it comes to these applications being made. Although when we're discussing the supervision orders, one thing that does occur to me is, for so long as the bridging R visa regime is in effect and it's valid and it hasn't been struck down on Chapter 3 grounds, I can't quite see, given that bridging R visas are subject to precisely the same type of restrictions that a community safety supervision order would be subject, why the Commonwealth would even bother to make an application through this extremely onerous, kind of court supervised process, when without really any evidence of risk whatsoever, these conditions can be wholesale imposed upon people now. So this is a catch-all. Still, you would hope the result is that even if the applications were made in vast number against people in the future, through the process, through the thresholds that we're talking about, through the process of court examination, through the testing of evidence and so forth, the result would be not that every single person released from detention or every single person to whom NZYQ applies would be subject to these restrictions, that it would be a much smaller cohort. But I suppose we might all be back here in a year having a very different type of discussion.
Who knows what the future holds? Possibly George.
I'll go with Professor Williams.
You did mention, Professor Williams, that there are differences between the state-based and the continuing detention orders and the community safety orders. Are you able to tell us a bit more about what those differences are and whether you think there's possible constitutional challenges coming out of those differences?
Well, there's certainly the differences are significant enough that the High Court is not going to be bound to follow those earlier decisions. And there's a question from Luke there about whether we might see Ben Bricker and Thomas and Mowbray overturned. I don't think so. The court doesn't need to, and I actually can't see the court backtracking on its strong decisions in the terrorism area, authorising Parliament to detain, to control and the like. The real question is whether the court sees that as applicable to this area. The court's already indicated in overturning Al-Kateb that I think it sees some significant differences. It sees detention in this context as being particularly apposite where it's for the purposes of deportation, for example. That's very different from a context where you need to detain someone for community protection because you're dealing with the possibility of catastrophic loss of life. So again, the context is fundamentally different. The court is different. But when it comes to the specifics, they have tried to model it, but again, the fact that it applies to people convicted in overseas courts, that's significant. Otherwise, I think it's mainly the context. That's the number one for me. I wouldn't draw too much otherwise from the differences because they really have tried to model it as much as possible. But it's a new case, new context, and all bets are off as to what happens. It really is very difficult to predict. And as I would say, partly it's difficult to predict because the High Court made a wrong turning in 2004. It's now trying to make up 20 years of legal assumption based upon Al-Kateb, and that's fiendishly complex because in that time, Chapter 3 litigation has been the most litigated part of the High Court docket and very difficult, very hard to predict, and a lot of inconsistencies between different cases.
There are, and there's a lot of complexity behind a lot of the cases, as we've heard.
It is the most complex area of constitutional law. It is very, very hard, this area, and NZYQ really doesn't tell us much. It gives us a test, a little bit of guidance, but really it tells us very little, and it doesn't answer the really big questions. Time. What do we mean by these terms? When is something reasonable? You've got the issue, of course, coming up shortly. What does it mean if there might be a fault element? If someone is complicit, if we were to take a pejorative term, in why it's not possible to deport them. These are unanswered questions for which the court at this point has given zero guidance.
Well, let's go to that. Many of you will have heard about the case of ASF 17, which is currently before the High Court, due to be heard on the 17th of this month, I believe. That case, for those of you who are not familiar with it, involves a man who has said that he who is refusing to cooperate. So Marty, correct me if I get this wrong, who is refusing to cooperate with the authorities, the Iranian authorities, to allow for his deportation back to Iran because he says that he has a well-founded fear of persecution if he goes back to Iran, notwithstanding the fact that his protection visa has not been successful, or his protection application has not been successful. So what do we think is going to happen with that case? George?
Yeah, it's as I said earlier, I think a lot depends on the facts of these cases at the moment. Because I think the instinctive reaction of the court will be to say if someone's not complying or otherwise being of assistance in this area, that's likely to tell for them. I think that's my gut feeling as to what the court is going to say, because otherwise you simply have that situation. People will decide not to comply simply to take advantage of the NZYQ ruling. So I think there's a good chance the High Court will see an exception to its recently developed test for people who don't cooperate. The real question is, was it justified not to cooperate? Could the judges see in a particular case that, yes, they didn't, but it was entirely reasonable they didn't? To take an obvious example, if someone's in a coma and they don't cooperate, well, the court's unlikely to say, fair enough. But there's a spectrum there, and it depends upon the strength of the case. And really, I'd be keen to hear from San Marti in particular, because I think that for me is what this sort of case would turn upon.
San Marti?
A lot of my future plans depend on George not being right about a lot of things. So like things are not looking good for me. But what I think that, so I perhaps shouldn't say too much about, the case and how we're hoping that the court will decide it. We, on behalf of a client of ours has sought to intervene in that case. He's directly impacted, he says, by the way that the issue was decided. So AZC20 is the pseudonym that he goes by, and his facts and circumstances represent, I suppose, the other part of this non-cooperation spectrum. So if one side of the non-cooperation spectrum is represented by the facts that were under discussion in Plaintiff M47, I suppose an extreme would be where you lie about who you are, or you pretend to be a national of another country, such that the removal duty can never logically be exercised in relation to you. So that's one end. And the other end...
M47, for those who aren't familiar with that case?
So M47 was an earlier attempt to overturn Al-Kateb and Godwin. And the court, in a very short judgment, I suppose by pre-NZYQ standards, said that the facts were not such in that case that the constitutional question could even be reached, let alone reopened, because the facts of that plaintiff's case were that he had, in the court's words, sort of obfuscated and obstructed attempts to remove him. So he had...
The keys to his own release was, I think, one of the lines.
Yeah. So that I suppose is one extreme end. And another end is, as George discussed, sort of mentioned, and I hope is represented by our client circumstances, where you've been detained for so long that you've been rendered mentally and physically unfit to cooperate with your own removal. So you're not cooperating, but that is the context in which you're not cooperating. And to detain you further will only compound your so-called non-cooperation, because it'll make you more sick. So there's a very, and what our client argues is that there shouldn't be some categoric carve out to the principle articulated in NZYQ by reference to this new concept of non-cooperation that's sort of been confected by the Commonwealth, but rather questions of cooperation and non-cooperation and so forth are relevant only when it comes to the application in individual cases of that constitutional limit. That's the argument that we make on behalf of our client. And it's the argument that's made by the plaintiff in one of the many ways that he puts his case. And so I suppose we'll see. But, there are many, many different ways that a person, and one thing, I'll come to it when I respond to the questions as well. One interesting and thorny issue when it comes to non-cooperation on the basis of protection obligations is that ASF 17 and indeed our client have been refused protection, but through the lambasted fast-track process that's been internationally criticised and is about to be abolished by the Labor government from the 1st of July this year. And the defects in that process have been recognised to the extent that people who were previously through it, granted temporary protection, have been rolled on to permanent protection visas. But there are people still in detention who have been refused protection, but obviously believe that they are going to be harmed to the extent that they've not volunteered to allow themselves to be removed for a decade. So there's obviously some basis to that belief, right? So this is the very murky, difficult area that the High Court's going to confront in literally 2 weeks from now. Hopefully not issuing an ex-temp judgment and ruining our weekend. But these are the type of issues that arise, and hopefully, if our client is given leave, these 2 factual scenarios in which that issue can be grappled with.
And I should also say what's significant with ASF 17 is the Commonwealth itself has sought to remove this into the High Court. So this is the Commonwealth, as much as people who represent refugees itself, trying to work out which are the cases the High Court will determine and in which order. And I suspect they've looked at this and said, actually, we think this is a case that will be effective in winding back NZYQ, building an exception. We can then build upon that in future cases over the coming years. That's how you work these things through. And I think that issue of personal fault is something the High Court is likely to respond to in limiting its earlier decision. And that's their strategic choice, but that's the way these cases are going to work out. Both sides will make choices about what they want litigated, and people who choose the right cases will have a big impact on the future direction.
The law is just as impacted by the cases that don't proceed as the cases that do.
And very often it's the cases that proceed which shouldn't proceed. Native title's a good example of this, where cases proceeded at different times that caused enormous problems for future cases, and you can understand why people were keen. Stolen generations litigation's another very good example of this. And but once you set down a precedent, it gets very hard to shift. So you make your choices carefully.
We hope so. We're now at a time that we can take questions from the audience. We have a couple of roving mics, I believe, up the front here. Are there any questions in the room? I've got a question that I can go to online while you come up with your thoughts, which is about the new legislation that was introduced and then blocked last week, happily it happened on a Tuesday, so not late enough to ruin our weekends. But the question is whether if the bill does or doesn't pass, what impacts that's going to have on people remaining on bridging visa Rs, or potentially going into people who are released, potentially going into criminal detention if they don't cooperate. So for those of you who aren't familiar, this legislation sought to criminalise people who elected not to cooperate with attempts to have them deported. So in the case of ASF 17, he's not cooperating for reasons that he feels at risk if he was to go back to Iran. If this legislation was to pass, my understanding is that would be a criminal offence, which would require mandatory detention for at least 1 year, up to 5 years. So the question is essentially what impact either the passage or the non-passage of that legislation will have on visas and detention. San Marti, did you want to start with that?
Yeah, sure. So I suppose the question, if I'm understanding it correctly, sort of asks us to postulate on these 2 different universes where the bill doesn't pass, what will happen to people who have been released from detention, and if it does, what will happen. So let's take the better scenario first. If the bill, many people were released from detention, including Mr. Al-Khatib, after Al-Khatib was decided, ironically. People were released from detention. There was simply, and the Commonwealth made various assurances to the court that it was in the process of reviewing the detention of people like Mr. Al-Khatib and Mr. Al-Khatib himself. And the result is Mr. Al-Khatib is somewhere in the community now an Australian citizen. So, back in the day, we used to have, I remember, when I started practice, all the way back in 2011, I had a client, a Rohingya client on a bridging R visa. He's now also a citizen. So there are quiet ways and means through which people's status has been regularised over time, and this category of people are not new. It's just that they've been politicised in a particular way. Not only are they not new in the Australian context, they're not new globally. There are, refugee receiving states throughout the world have grappled with this concept of what happens when people aren't admitted as refugees and yet cannot be removed from the frontiers of the country, what then to do? It doesn't lead to the kind of political systems collapse that NZYQ appears to have done in Australia. So there are ways, and keeping in mind that a lot of the people who, as I've just mentioned, I don't exactly have the breakdown, and we should be seeking it through the Senate estimates process, but the number of people who are in long-term detention who are there because they've been failed by the fast-track system. So a very, very obvious way to regularise their status is to permit them to reapply for protection visas and have them properly assessed through the same system, robust system of review that everyone else gets access to. So that would be universe number one, least bad. Universe number two is where the bill passes. Then we have serious problems, and I would absolutely invite everybody on the call. The Senate committee is receiving submissions until next week. Even something brief, I think, would really assist. If the bill were to pass, it would capture not the entire cohort of people affected by NZYQ, keeping in mind that there are a range of reasons for which people cannot be removed. So people subject to non-refoulement obligations, unless those obligations are revisited through the mechanism that's created by the bill, which is another nefarious part of it, or people who are stateless would, of course, not be affected. But people who would be affected are people like ASF 17. The only mechanism that I would see, one thing that I think that we should begin to give really serious thought to, including in future, depending on the way that ASF 17 is decided, including for the purpose of further habeas proceedings for habeas corpus, is preparing evidence relating to the mental health of our clients and what, in fact, immigration detention has done to them. Because the reason for people's non-cooperation with going home is not simply because they have an utterly baseless subjective fear of returning to a place, but it's also oftentimes because they are physically and mentally deeply unwell, including by reason of their detention. So there will be those matters and evidence of that nature could constitute a reasonable excuse. It could inform a prosecutorial discretion or so forth. But when we're getting to that stage of the government criminalising your non-cooperation with going back to a country where you absolutely committedly say that you fear harm, we've gotten into a very, we're in very problematic territory that I hope we don't end up in, but I fear that we will.
Paul, did you have anything?
Not my area, I'm afraid. I'll
George?
defer.
I could just say it's hard to predict what the impact will be because it's such high stakes lawmaking. Last year, of course, Parliament made a law after the decision, but before the reasons coming out in NZYQ. That was tough. Now they're making a law before this new case has even been heard, let alone decided. And that case may have a major impact in this area. So I think the tricky thing for the Commonwealth is that it may be subjecting itself to ongoing cycles of lawmaking in this area, which isn't really good for stability, not really good for community confidence. And we will have to see what happens with this case. It may require significant amendments to the legislation depending on the result. Until then, all we can say is it stands for what it purports to do, and that's more a policy question than a constitutional question at the moment, I think. But yes, we'll see what the inquiry decides and whether it's actually enacted.
We will indeed see. Any questions in the room? Yes.
Yeah, good evening. My name is Jack Pembroke-Burse. I'm from Norton Rose Fulbright. Thank you to the panel for your excellent discussion this evening. My colleague and I, India Bennett, have been acting for DVU 18, who commenced proceedings in the High Court against the Commonwealth and the Minister for Immigration. And he's a stateless Kurdish man who brought 3 claims. He's part of the NZYQ cohort, one administrative law-based, constitutional-based against the 2 conditions you were talking about before, the curfew and the ankle bracelet, and also a false imprisonment claim. And those administrative and constitutional claims have now been discontinued, and his claims been transferred to the for false imprisonment has been transferred to the federal court. My question is really aimed at Professor Williams, and I'm interested. I've never seen the High Court striving for unanimity like they did in NZYQ, where you have 6 judges talking about what they think, and then 1 judge talking about themselves in the third person, all in one set of reasons, Justice Edelman. And I wanted to just ask Professor Williams, how do you perceive the 2 different tests, and do you think Justice Edelman's test of reasonably necessary legitimate purpose is going to have legs in the future?
It's a good question, and I've never seen a decision like this either. And That's having written a lot about this area, studied decision-making for the High Court, but to build in what was essentially a concurrence into the decision was remarkable. Hasn't happened to my knowledge in 120 plus years of the High Court handing down decisions. And I think, as you indicated, it shows the High Court was determined to show a single unanimous face, even though it wasn't really unanimous. There was a separate approach taken. I think the fact it was 6-1 on that point gives us a strong sense as to how the High Court's likely to approach it in the short term, at least. And Justice Edelman's an interesting perspective, but not one I'd be relying too heavily on. And I think given the court there's been a lot of criticism directed at the court politically, I think they'll be wanting to stick to that bedrock of what those 6 judges say and really play it as much down the line as possible, provide as much certainty as possible. And I think also they will be alive to the fact as to the position the Commonwealth has been put in and looking for ways to help short circuit some of these rounds of lawmaking we've got. So I think, look, it's interesting what Edelman has said, but hard to see that it'll be picked up in any meaningful way in the short term.
So Marty, did you have anything to reflect on there? I know it was a question for...
I'm having some exceptionally difficult tech issues, so I might leave you with it and see whether I can resolve them.
No problem at all. Was there any other questions in the room? Margaret.
Yes, I reiterate the thanks. It's been fascinating. So Marty, you've spoken about a time when complicated matters were resolved quietly and sensibly and without a great deal of public attention. And I think we've just gone through the absolute opposite after NZYQ, where I think it would be fair to say that there have been rarely a time within the parliamentary process where there has been as much vitriol, nastiness, mistruth, distortion, and active generation of public fear. I mean, if you go and ask sort of Joe Average in the street, you know, the decision has created a massive threat to the entire population. Oh, she's gone. I despair about the political environment and would be interested to get some reflection on how we can avoid the spiral of legislation and litigation that looks inevitable. What is the messaging that can go out? What is the advice to government that can stop this? Because within all of this, there are human beings and we're playing with their lives. And by definition, they have gone through a huge amount in the past.
I think that's really important to remember, is how real the ramifications are. We heard at the beginning about some of San Martin's clients, and there'll be dozens of people. Everybody who's been released will have one of those stories or something similar to that. San Martin, can you hear us at all? No, okay. George, did you have any comments?
Yeah, I can start. It's a really good question. And I suppose I'd say that sadly, we have gone through these passages before a number of times. In fact, many times. I can even say go back to the early 1950s when we had bans on communism. At that point, Menzies actually directed an attack on the opposition, saying he might actually seek to prescribe some opposition members as communists. It became very bitter. What's been different over the last 25 years or so in the terrorism context is it actually hasn't been divisive. It's been bipartisan all the way through. In fact, I can't think of a single of those 100 anti-terrorism laws that was opposed by the opposition. They tend to sail through. It's no different, I think, now in this area, except the opposition's just delaying a bit. I don't think there's much doubt they'll pass the latest measure. So it's a really difficult problem because we have an overwhelming number of parliamentarians willing to pass very stringent laws. And to my end, I think it goes to the fact that we have such a weak system of protecting human rights in this country. We don't have the checks and balances other countries do. In fact, Al-Kateb, the judges in that case, identified how different we were to other countries which wouldn't go down this path. And I'd say the Australian Human Rights Commission's just delivered a great document saying how we could have a National Human Rights Act that would change the debate, change the language, hopefully start changing the political culture. And for me, it's those bigger systemic issues. Politics is too hard. It's not going to change. So we have to change the structure and the education. And for me, that's where I'd be putting my efforts. And I have put my efforts because I'd like to see it change.
I think that's, San Marty, did you have anything to add to that? You may have missed the question.
I think George's response has given me the gist, and I think we better leave it at that. That's what a great note to end it on. I think that's precisely right. That the problems in our political culture grow around a critical lacuna in our system of law, and so much has been identified for over 20 years, and it needs to change, because this type of extreme demonisation of 150 people is it's just cancerous, I think.
I read today Annabelle Crabb describe this area of law as the alien versus predator of law, with the politicians being the aliens and the lawyers being the predators. I'm not sure whether we would agree with that or not, but it is certainly a very vigorous debate, and we keep receiving quite serious legislation. It has massive impacts on our clients, and responding with all of our predatory abilities. So we will leave it at that. I want to thank our panellists immensely for such an incredibly fascinating and enlightening discussion. It's been so fascinating to see the analogies between immigration law, constitutional law and criminal law, which previously you would not even consider went together, but with the way that the law has been developing in the last 6 months, seem to be coming more closely aligned. This event has been run through the Caldor Centre Strategic Litigation Network. The network seeks to support strategic litigation that's relevant to refugees by running events like this, and by putting lawyers practicing in the area in contact with academics with the relevant expertise where that's possible. So if you're interested in the network, please do let me know.